So welcome to the new faces in the room. We're really happy to have you join us for this part of the conversation. And there may well be a couple of people that come in over time, so we'll just, if we can shuffle around and make some space if that happens. So I'd like to thank very much both Nicolette Naylor from the Ford Foundation and Sibongile and Dashe from the Initiative for Strategic Litigation in Africa. We abused our relationships with them to convince them to continue a conversation that they started on the 10th of July in Joburg around these questions of sexual harassment and the law. And it was really just such a great conversation that we jumped at the opportunity to be able to continue that conversation here in our space, in our spring school around social justice lawyering. So thank you both. I hope you will not mind if I don't take up time doing long bios, because I always cringe when people read out bios of my own. So I'm going to hand it straight over to the two of you, and we look forward to the next short while. Thank you.
So good afternoon. It's a pleasure to be here with you this afternoon to continue this conversation. So Nikki and I worked together about 16 years ago at the Women's Legal Center. Nikki was working on violence against women, and I was working on women's access to resources. Life took us through a lot of different paths. Nikki is the more famous one with the converted signature. She signs autographs that people really want to see her signature. And I'm the one who stayed. She frees money from its misery. That's how I say that's the job that she does at the foundation. So for us, the conversation is about how much has changed and also about how little has changed, because the conversation has really been, where it started is when this conversation around sexual harassment in the social justice sector, but also the global conversations around Me Too started, was what was it about this moment that was different? Have we lost ground? Are we gaining ground? So the first conversation was really going back, looking at legal principles. But today I think the conversation is slightly different, because we say here is the law, and then the conversation really centers on case law, how the courts have really tried to grapple with sexual harassment over the past 15 years. So I think that's where we are going to start the conversation.
Perfect. Good afternoon, everyone. I haven't practiced law in a long time, so that's my first rider that I'm saying. But when I did practice, this was an area I spent a lot of time on. I also spent a lot of time with the drafting of the amended Code of Good Practice on sexual harassment with Ned Black at the time as a civil society representative. And I litigated the Insabo case, which some of you may have heard about or not, around vicarious liability. So I've been out of the space. What's been interesting for me has been to go back and look at what's happened since then, in terms of the good and the bad and the ugly, and try to understand what does this mean. You know, often we think when we have a good code of good practice, or we have good policies and laws, that somehow that's going to change things. And to some extent it has, and to another extent it hasn't. But maybe we can start at the beginning, I think, in terms of the common law. I understand most of you are law students in the class, and I think maybe we should talk a bit about the early decisions around sexual harassment, and one of the first cases that was decided around this notion of whether to hold an employer liable. So earlier it was very much around dismissing people for sexual harassment within the work context, and we can talk a bit about how that's evolved. But one of the earlier cases where they dealt with this notion of vicarious liability was the Sonia Krobler case in Media 24. And there it was really around, normally, and all of you who have done dealing in vicarious liability, the employer is only held liable for acts of an employee if it's in the course and scope of employment. So usually the defense is this employee went off on a frolic of his own. So an example would be if someone sexually harasses you at work, that's clearly not in the course and scope of the employment contract. No one has an employment contract that authorizes them to do that. So it's outside the course and scope of employment, and therefore an employer can't be held liable. So the courts were interpreting this in light of the Constitution in Sonia Grobler and said that the Constitution requires notions of vicarious liability to really evolve with notions of fairness and justice. And so what they found was because there's a sufficiently close connection in a case, and in that case they really looked at the nature of the relationship between the perpetrator and the complainant, and they said there was a sufficiently close connection where the employer actually puts the manager or the supervisor in a position to harass the employee. And in that case, it was a manager, secretary working for a manager, and a manager was harassing her. They said that supervisory relationship was a sufficiently close connection to establish vicarious liability. And so in that sense, then you started to see the test there was really around the nature of the relationship. It wasn't about what the employer did or didn't do once they found out about the harassment. It was more about just this in the course and scope of employment. And subsequent to that, you had a number of high court decisions that have looked at this notion of vicarious liability under the common law. And a lot of it was involving police officers, the rape cases, and some of them the Women's Legal Center were involved in at the time. So the Constitutional Court also dealt with this, where in the matter of F versus Minister of Safety and Security and K versus Minister of Safety and Security, you had police officer in uniform, on duty, raping a woman who was looking for a lift home. And the woman sued the Minister of Safety and Security, and the court said that's clearly in the course and scope of employment. The fact that you're in your uniform, on duty, holding yourself out to be responsible for safety and security, we can infer that there's liability on the Minister of Safety and Security. So you couldn't say that the police, that when they were embarking on those rapes, were out on a frolic of their own. The Minister of Safety and Security was saying, look, it's clearly outside the scope of employment. The courts were saying, no, you created the means and the mechanism, and you should be responsible for what your employees do. So you start seeing our courts looking at a really high duty of care on an employer to make sure that your employees are doing the right thing when they're going out into the world. Whether you knew about it or not is not relevant. Whether it came to your attention, whether you took disciplinary action, it's a form of liability that arises by virtue of the employment relationship that exists. And so it's interesting that you had a sexual harassment case there with the Grobler case, and since then we've had another case where, it's the Old Mutual case, Pilasso case, where they've said basically a non-employee rapes a woman on the premises of Old Mutual, and she sues Old Mutual saying, you have a duty to make sure this is a safe environment for me. She doesn't use the Employment Equity Act or the Labor Relations Act. It's a common law claim that she brings saying there's a duty on you to make sure that I'm safe when I'm at work, and you fail to keep me safe, whether or not Old Mutual knew the rapist or not, and you entitle them to general damages. So those are the general damages claims for future medical expenses. So you can see there's a divide in our law in terms of this common law notion, and then we get the Labor Relations Act and the Employment Equity Act, which really imposes a form of statutory liability under the statute.
Yeah. And so when we start moving now into labor law and leaving the common law duty of care, then there's a higher threshold for employees who want to be able to hold employers liable. And in that way, I think as we go through the cases, what we are going to be able to see is how what we thought was going to be helpful, the Employment Equity Act, as it is, has really not been able, to do the work that we hoped that it would. So because Grobler, it's the beginning of this expanded liability for employers And where we were coming from with the Employment Equity Act was that there was now this positive obligation to make the workplace free from discrimination. So we're not only looking at sexual harassment, what it did was push forward this idea that sexual harassment was a form of discrimination. So whether we were looking at racial discrimination or sexual harassment, that we were going to be able to work to deal with it under this new framework of the law. And all of these things were exciting because under international law, we were developing standards around due diligence, which were saying that the states were responsible, for failing to protect or creating an environment where impunity thrives. So this was around how states were being held accountable for actions of third parties. So in some ways, it was a way in which everything seems to be converging. We have the Constitution, we have labor law, we have international law on our side. That's a saying, whether you are a state party, whether you are an employer, but you are responsible for the actions, of other people. So the question then becomes, because what we get from Grobler is really no need to look at a lot of other things. It's what's the nature of the relationship. So you have employed this person, and therefore you are responsible for what this person has done. And it was easy, I think, for the Constitutional Court in cases like NK and all other damages cases that flow, from that principle, that if you, as a state, if you employ a policeman and a policeman continues to rape, so that's not the standard test of vicarious liability, but because of these constitutional obligations to infuse the Constitution on common law and develop it, it was possible to develop it because what the courts were doing was going back to look at what was it that the police were supposed to do. The police were there to protect us. So if you saw a police van and you went there because you thought they were going to help you, then that relationship that you have with them, that's what allowed you to go there. You didn't just stop a stranger and then say, I need help. And therefore, because of that relationship, it was easier then to use that standard for employers. But what was not clear that international law was beginning to do, that the Constitution was not really looking at it to say, okay, fine, I can see how I incur the obligation because I have employed someone who's gone off, so it's a deviation test, it's not a standard test for vicarious liability. I get that. But what you are not saying is really around the trigger, which is what has become important under labor law. So under international law, when we talk about the duty to protect, we are saying that it is twofold, right? So the first aspect of this is that you have the duty to prevent a violation, right, before it occurs. And then the second aspect of the duty, which is more procedural, is the duty to respond. And that's when we are talking about the duty to investigate, prosecute, and punish once the violation has occurred. So here we had the state that was held liable. The duty to protect, we were looking at one, that we had failed to protect, but we were not looking at whether it was the first aspect of the duty, the substantive one, to prevent the violation from occurring, or the second aspect of the duty, which was responding to the violation once it has occurred. Under constitutional law, we're still looking at it in that way, although there are cases now. I think there is the Ndiawa case from PE that is beginning to look at this nature of the state obligation to respond, where people are taking the state on for failing to conduct effective investigation. So under sexual harassment law, then this distinction became quite clear, and I think that's what we are seeing from the cases that are coming from the courts to say, in single instances, courts are saying, but why? Because you were not complaining that this work environment was toxic, right? So you want to hold us liable for having failed to prevent, sexual harassment. And so you're beginning to hear courts saying, the first time they heard about it, they did something, right? And so that's what's reasonable for an employer, to do that. When you find out that sexual harassment has occurred, this is where Section 60 is taking us, because it is setting out the requirements for what is it that an employer needs to do in a case of sexual harassment. So in some ways, Section 60, it's supposed to provide a framework for how employers need to respond. But in some way, it has really clipped, our wings, because the statutory framework is quite limited, because we're not longer asking the broader question that we were asking under Grobler, under common law, the question that we were asking under the Constitution, that simply focuses on the nature of the relationship and also the nature of the obligation that we got there. So Section 60 is really both it's a blunt knife, but it's also a sharp knife. So
I think it goes to this notion of how you interpret, how the courts have interpreted it. We've got some good decisions from the Labour Appeal Court and some bad decisions. I think what's clear, what's helpful about the Employment Equity Act is the sexual harassment is a form of discrimination. There's a duty on employers to act, to do something, and to prevent it from happening. So that part, under the Employment Equity Act, you have that framework. Under the Labour Relations Act, you can dismiss an employee for sexual harassment, for example. So usually the cases would just involve that notion of you can take action for dismissal of a perpetrator. Now you can say, irrespective of that, you're going to hold the employer liable and you're going to use Section 60. Now what section, I don't know if you guys have discussed Section 60. Okay. So Section 60 basically requires you to, there's a test that it sets out to hold an employer liable, and you can claim damages from the employer. But it's not like the common law, which is almost like a strict form of liability. Here, you must prove that you were sexually harassed by an employee in the workplace. It must have happened in the workplace. You must have reported it immediately. So the word immediately has been the subject of a lot of cases to the employer. The employer must have failed to take any steps once you reported it to the employer. And the employer must have failed to take reasonable actions to ensure that there's no sexual harassment in the workplace. Once you show that, then the courts say you can hold the employer liable. So the easy cases have been, so the Sabo case was almost a straight, Sabo versus Real Security was a straightforward case almost under Section 60, where you have an employer that does nothing. So you go, you complain, they don't have a sexual harassment policy, they don't believe you, they ignore you, they just put you in harm's way, the harassment continues. It's a straightforward Section 60 case. You brought it to their attention, it happened in the workplace with a fellow employee, and the employer failed to do anything once you reported it. And then the courts will come to your rescue and they will find against the employer will be liable for damages. So then you must remember this is beyond the dismissal of the perpetrator. The employer is now then providing a remedy to the complainant. And so that was a useful thing for us. We always said we wanted remedies for complainants, not only that the perpetrator gets dismissed. So like in Sabo, you could claim for general damages, for pain and suffering, for future medical expenses, because the Employment Equity Act also allows the court to give appropriate relief and appropriate damages. So that was Section 60. Then often in Sabo, the cases that came afterwards, we found it's difficult when you have an employer, a sophisticated employer that does have a sexual harassment policy that you do report to, and they do something. So the court then said we had a problematic case, the Mokoena case is quite a problematic case, which basically sets out, and Potgieter also laid out, that if the employer just does something, even if it's not the best thing that they do, they don't have to be the most reasonable response, as long as the employer does something. So the women there were cleaners, they complained about their supervisor harassing them on an ongoing basis. Whenever they went to change into their clothes, the supervisor would come and harass them. When they went to fetch their wages, he'd want to fondle them before they could get their wages. The fact that they didn't report that immediately was a problem. So the one complainant didn't report it immediately, and in the case they found she didn't have a case under Section 60. no context around how difficult it is in a power relationship to go and report to your supervisor. The second complainant did report it immediately, and so the court looks at her very favorably and says, so let's proceed with the test. But then the supervisor and the manager called in everyone, and they said, okay, this did happen, but he's apologized and we've given him a warning. End of story. No claim against the employer. As long as the employer called the person in, there's no duty on the employer to do anything else under Section 60. And so that was where we started to see some problems with Section 60. Luckily, the Labour Appeal Court has pronounced on this now, saying we can't have such a narrow interpretation of Section 60. Firstly, immediately, it should be as soon as reasonably possible, taking into account that victims often don't come forward immediately, especially when there's a power dynamic. The notion of at the workplace, and I found the most, what's interesting about the Employment Equity Act, the most progressive decision that we've had on Section 60 doesn't involve sexual harassment. It involves racial discrimination, where the court was willing to take a much broader interpretation. Up until then, the courts were very like, who are we to be armchair critics? The poor employers trying their best, as long as they just have some kind of meeting, that's all that they need to do. In the racial discrimination case, they actually said, look, racial discrimination is so serious, it impairs people's dignity. In that case, the employer had taken action. They'd given people a warning, and the racial discrimination continued against the employee. And they said it wasn't enough to just call people in, give them a warning. You actually need to do something proactively in the workplace to make sure that the workplace isn't a workplace that's filled with a toxic environment. And this was a black family living emergency services. So they all lived together with white people, and the black family were being harassed, and eventually the man's wife got beaten up by people, and he kept going to complain, and the supervisors would say, yes, we're going to warn the people, and they'd let their dogs out to chase the children. It wasn't happening at the workplace, it was happening at the residence where all the firemen stayed together. So it wasn't in the workplace, and the employer did take action and had given warnings. And the court, they said that's not enough actually. The way they were giving warnings and not following up, and the way this was escalating, was enough to hold them liable under Section 60. In the sexual harassment cases, that hasn't happened. We had a case, a rape case, a very serious rape case, where a chef was raped by her supervisor, brutally raped and beaten up and put in the boot of a car on the premises, and was eventually unconscious and rushed to hospital. The employer there decided that there was a criminal case that was running. The police had told them they don't need to do anything until the criminal case runs its course. So the chef that had raped her was allowed to continue working, and they told her she will have to transfer somewhere else until the case runs its course. So she had to transfer to another place. She earned half a salary at that place. She was severely traumatized, and she eventually left the employment, and she tried to hold the employer liable. They said, look, eventually we did dismiss him, but we were waiting for the criminal case to run its course. When the criminal court found him guilty, we dismissed him. The court goes through Section 60 and says, sorry, there's nothing we can do for you. We feel for you, but the employer's actually done everything that's required of them. Now, I would argue that it required a much wider interpretation. The duty to protect would mean that actually you can't just transfer the woman. She needs to go work somewhere else, earn half her salary. There you already, your duties, you're not fulfilling your duty. So in that sense, I'm finding the racial discrimination cases on Section 60 much more useful. And the interesting thing is, if you go under the common law, what the employer did means nothing. In the Grobler case, in all the common law cases, they're not going into a whole inquiry about when you reported it, what did the employer do. And so what we thought Section 60 was going to be a really good thing for us to use to nail employers has actually been quite a mixed bag in terms of holding them liable.
So when you start looking at the cases under Section 60, there is a pattern that begins to emerge. Who are the people who go all the way to the labor court, to the labor appeal court? So most of these cases are still cases where people who have been dismissed appeal all the way. And sometimes you may find that, so mainly it's men who are the perpetrators, and therefore they will go all the way. But sometimes people who proceed are the employers who feel that it's not going to make sense for this person to come back, especially where they have ordered a reinstatement. So they will take it all the way to the Labor Appeal Court. So the most kind of progressive cases come from the Labor Appeal Court because they seem to get all of these things. So whether it immediately sort of makes sense that you must, and the analysis about why sexual violence and all of those things and sexual harassment is not something that people deal with, because of course it was weird even then that you would have immediately, because people who've been working on violence against women know how violence sort of manifests, and that many people do not report, immediately. And there's a lot of work and literature around why people respond to these kind of violations in the way that they do. But in a labor context, it sort of made sense to them that if you want the employer to do something, then the reporting must be immediate, until the labor appeal courts then started analyzing that actually it's not really that much different from violence that women experience everywhere, and so you can't have this very strict reporting timeline. But the other things that are coming there from there, it's that because the women as victims, and this is what we see in the criminal justice system, appear to be represented by the employer. And so even if there are findings of credibility and other things about them, and the employer decides that this is where they are leaving the case, all of those things that are problematic that are coming from cases like believability of women, the way in which they responded, that you were not dismissive, you seem to have liked it, you accepted the compliment, you said thank you, that those are some of the things that remain untested, unchallenged in the jurisprudence. Why is it that someone who would later say that she has been harassed would say thank you to something that's not a compliment? Like, why they wouldn't challenge it and say, please do not call me that, please stop commenting on my clothes or everything. Because when they decide to use all of this as evidence that she's had it, for him, maybe it's human resources that's forcing her to now try and get rid of this person from the organization, that what we don't have a lot of, it's basically how women in the workplace are asserting, their right to be in a workplace that is free from discrimination and harassment, because of who are the people who are leading these cases and what are the issues that are going to the Labor Appeal Court. Then this is also linked to how courts decide who is worthy of legal, protection. So the Mukwena case, where women were domestic workers and where the courts have said, we don't see this, so you didn't respond on time. So even when people are trying to establish a pattern, the courts would penalize them and say, you caucused. You first sat there together and you talked about it, and then now you have come to report, and therefore there is something wrong. So it's basically the opposite of the Me Too movement, that women are dealing with this fear, the question of believability, by being able to say, oh my gosh, it happened to me too. Yes. And then seeing that as something that's negative, that should not happen if you are going to be able to bring a credible case, before the court. But also some of the things, it's around how the courts, when they have tried to look at issues of damages and when they've really gone to award people proper damages, it's mostly been white women who have been, the complainants, and so it's one of those things that continues to happen in court cases. So the one was Christian, the Colliers properties.
That's quite an interesting. I like comparing Christian versus Collier's properties with Mokoena because Christian, she was employed for 2 days. First day of employment, her boss took her out for dinner and had her sit on his lap and was trying to kiss her and basically said to her, and she said, no, I'm not interested. He said, are you in or out? And she said, I'm not interested. And he said, well, then you're fired. And the court then said, look, under the Labour Relations Act, that's an automatically unfair dismissal because she was saying no to him. And she's entitled to 24 months compensation, even though she was only working there for 2 days, even though this happened on one night because it was, she was so traumatized by what happened to her. So she gets the 24 months, she gets damages, she gets medical expenses, she gets interest, legal costs covered, versus the Mokoena cleaners who don't get anything. And the court really makes credibility findings against them based on the fact that she's a shop steward, they were trying to cause problems in the workplace, the fact that the women all got together in a meeting, the women who were just getting frustrated with this man coming into the room, watching them undress, and their white supervisors looking at them saying, you're just a bunch of troublemakers and, we're not going to help you, you're actually lying. And the court reinforcing that notion about who gets believed in courts. You also find if the perpetrator's black and the complainant's white, there's an interesting analysis there, I think, around how judges look at the harm that was caused to the woman. And so that's quite problematic and needs to be challenged and unpacked. And women don't take these cases further. So Mokoena could have appealed, but those women didn't appeal that case. The most appeals, all the Labour Appeal Court authority that I found have been the men that have been dismissed. So the other case that you were referencing was the Anglo-Platinum Gaga case, where Anglo-Platinum or Liberty or the old mutuals, they take those cases all the way to the Labour Court, Labour Appeal Court, where the Labour courts have ordered them to reinstate someone. So what's often happened in the Gaga case, the Labour court found they didn't believe the complainant. They said, she was enjoying the compliments, she wasn't forceful enough in the way she said no. And they actually analyzed trails of emails and WhatsApp messages, from the complimenting of the shoes to the progressive. And we all know sexual harassment doesn't always start with a horrific instance. So your supervisor compliments you, you say thank you. That gets held against you down the line because you started off by saying thank you, you must have liked it. The Labour Appeal Court says no, we must always look at the power dynamics at play. A woman that's in a very junior position where there's a power dynamic, where there's an older man, a younger woman, the ability to just say no up front and go lodge a complaint immediately, they'll often wait for a few instances before they go and lodge a complaint, and you can't hold that against them. And the believability aspect, they also say that shouldn't taint the credibility of the witness because of the way they say no or the way they respond. So the courts have come to, they have come to the party in terms of taking a survivor approach. But I do find that there is a race class analysis that's needed in terms of when they're willing to come to the party, because it's not very consistent.
So then that takes us to this assessment of whether harassment occurred or the seriousness, of the harassment. Because here, just trying to look at case law in the perspective of the complainant, because there has been a shift from the standard of a reasonable man, who often turned out to be unreasonable, to saying, if you are saying, is this sexual harassment to you, or is this sexual harassment to everyone? Because many people would say that's not serious enough, so that's what was coming up. But linked to that, it's a question of how rough must it be?
Yeah.
Must the person be raped you know, for sexual harassment. And I think this is something that we struggled with when we were litigating kind of test cases, just trying to see whether the law was making sense to say what should the first cases be, because once you set the standard on the horrific, you know, ones, and these are the cases that actually we are looking at, that people are getting raped in the workplace, then there's the other kind of microaggressions that people are dealing with every day, where you yourself, you're not even sure if you are overreacting, you know, when something like that has happened, or even if you try putting it together that today, this is the greeting that I got, tomorrow this is the comment, you know how it's like gaslighting, and you are trying to figure it out yourself, whether am I imagining it or is it really happening, you know, to me. You have those moments of doubt. And the court seems to be reinforcing, you know, like that kind of distinction, that it really wasn't serious, or you actually didn't, like the SABC case, you know, that you did not seem to mind even when he French kissed you. So you can't come now and call it, you know, sexual harassment. So it's the thing we talked about earlier, that you didn't report immediately, but that you somehow allowed it, you know, to escalate. And so how can we believe you? Whereas in other cases where the case that we were talking about earlier, where the man said, you want a lover tonight, you know, and the cases there awarded a lot, you know, of damages for that. So what is serious, and who is it serious to, and why is it? It's still unclear. Why is it that the courts think that this is serious enough? Because they will say all the right things about what it means to go to a workplace, you know. So in those cases, when they say things like, do you want a lover tonight? And then the person did not persist and they went their separate ways, and the court still say that you need to pay her, you know. It was a dismissal case. In that instance, he was challenging his dismissal, and the courts are saying, no, you were okay. He does, you know, need to go, because it is a serious, you know, enough infringement, because she had left the victim.
That Labour Appeal Court case actually established that a single incident you can dismiss for. Because other cases like SABC were saying, you know, it's not so serious, it's a once-off incident. If it's a once-off incident and you say no, and the person responds and backs off and never does it again, then, you know, the employer doesn't need to dismiss. In the Simmons case, that was a complicated case, because in the Labour Court they actually said, look, they weren't in a supervisory relationship, they were on company business. After dinner, he propositioned her to come to his room, said, do you want a lover tonight? She said no, he left it. So the Labour Court says, that's not sexual harassment, it's sexual attention, you're entitled to play the field, you're entitled to test what, you know, you can keep trying until you basically. The Labour Appeal Court says no, in a work and employment context, that's sexual harassment, it's a single incident, and if the employer deems that unacceptable, the employer can dismiss. So they uphold the dismissal in that case. In other cases, they've said there's repeated instances, it's verbal, it's complimenting. The other case was around, you know, can't wait for summer to see you walking around the office in your gear in summer. And the court said, look, that's not so serious. So the courts have been pretty inconsistent in terms of, so I always say we can use the Labour Appeal Court authority where they've said things like a single act is still sexual harassment, where they've also said you don't have to have a supervisory relationship. You can be peers, because in that case they were peers. Most of the other cases, the courts are pretty harsh when it's an older man, younger woman, supervisory relationship. They unpack the power dynamic, the Labour Appeal Court. Whereas the lower courts and the CCMA, so the CCMA tends to generally, really, in the nature of the evidence they allow, the way they allow certain cross-examination, and their findings on credibility of women tend to go with, well, she didn't say no, it wasn't explicit. So they keep going on about the explicit nature of sexual harassment, whereas the courts have said innuendo is also sexual harassment. The way you email, and there's usually a progression in the way these things happen in the workplace. And an employer at any point can say, enough is enough, we're drawing the line here. The CCMA tends to say women have to scream and cry and be very emotional immediately and go and complain. If they keep quiet, some of them have spoken about it, the Labour Court has spoken about a docile response. A woman is having a docile response, and is unsure. We should be cautious. In the Liberty Life case, Liberty actually led a lot of evidence against the woman to say that actually she was after the money. She was just after money. She was suing Liberty because she was angry about her pay. She made up this whole story. And when it gets to the Labour Appeal Court, they say when they look at the record, they're quite horrified that the court allowed the extent of cross-examination they allowed of the woman. And she stood her ground saying, look, he was my supervisor, and initially I didn't say anything, but when I did say something, Liberty didn't believe me. So often you have the blue-eyed boy in an organization that's the harasser and is a senior person, and the organization doesn't want to take action. So in that case, Liberty took it all the way to the Labour Appeal Court because they also didn't believe the woman. Whereas in Anglo, they believed the woman, and the HR official, that's an interesting case, because in Anglo, this is an important decision also for criminal law purposes, because in the Anglo case, they allowed similar fact evidence. The Labour Appeal Court said, often in a sexual harassment case, there's no corroboration. It's just the harasser, the perpetrator, and the complainant. And in that case, HR had met with the woman. The woman went to do a resignation letter. And she said she wants to move to Cape Town. That's why she's resigning. She wants to leave Joburg. The HR official then says to her, how's things with your manager? Has he tried anything with you? And then she starts telling the HR official. So the Labour Court says, oh no, the company was looking to get rid of the guy. They were planting seeds in her mind. She says she then started to think about the sexual harassment. She looked at the policy, and then she said she wants to lodge a grievance. So the court says she never even thought of this until the HR official put it in her mind, and they were conniving to make the story up. The Labour Appeal Court says no. HR official says, I raised this because I knew other women had resigned in the past without laying a charge against this man, and I didn't want to see another woman resigning. And at the Labour Court, the perpetrator's counsel objects and says inadmissible, we can't lead this evidence, and they're not allowed to lead the evidence, it's rendered inadmissible. The Labour Appeal Court then says it's unfortunate that that evidence wasn't led, and in future you could allow, where there's a similar fact pattern with the perpetrator, an employer should be allowed to lead that evidence, which is a very different approach to criminal law where you're not allowed to lead similar fact evidence. And so I think that's a useful evidentiary rule that's come out.
So, I mean, in the first conversation, we did spend a lot of time looking at this issue that keeps on cropping up, this employer saying our hands are tied. And so here you see that human resources person basically saying we can't go after him, but we don't want you to leave because we know. That's it. There's no you wanting to go back to Cape Town here. You are leaving because you are running away from this relationship that is toxic, right? But we want your body, right? We want you to help us get him, because we feel that we can't. And in our discussions, we feel that this is the next frontier, because the duty is not just to stop sexual harassment, but there's a positive obligation that rests with employers to make sure that the environment is free from sexual harassment. So if there is a positive obligation, then it does make sense that when they know, even if the complainants are not willing to go all the way, that they actually respond to the sexual harassment, not because someone has complained, but because they know what's going on. Because this thing that courts are struggling with, calling it a single incident, it's not really a single incident, it's the trigger that we are talking about, because you know that in this organization there is a predator, but you feel like you cannot do anything because there is no complainant. Because then you know exactly what you are subjecting people, to. So it cannot be that when the women or the victims of the harassment are not willing to say anything or to do anything, that the employer continues to say that. But there is something that is also like the conversation around affirmative action. And the reason why it resonates is because we're dealing with discrimination here. That the courts, when the employer has dismissed, right, they normally find it easy to uphold the dismissal and then say all of these things that are progressive. But when someone is saying the employer failed to protect me, so it's still the same kind of obligation, right, which is about I have a right to be free from sexual harassment in the workplace. But when you are using it as a sword, right, to attack the employer who has failed to protect you, the court seems to be reluctant to want to do, something about it, because they are giving the employer that kind of leeway that, your circumstances, and that's when sometimes they would say things like, it's just small organizations like us, you don't have human resources, you wouldn't have been reasonably expected to comply with all of those things that are there, because it's too costly, to hold all of these proceedings and all of that. But that the case is then, if you don't have an employer who dismisses for sexual harassment, you seem to be worse off as a person who is going there and saying they have failed, to protect me, in this workplace. So the links with affirmative action, it's where, we started seeing the labor courts, because it's all going to the labor courts saying you don't have a right to affirmative action. So, but if someone says that because of I was not given a job that I believe that I was entitled to, and then the employer can use that as a shield, from a challenge on that they used affirmative action or that they discriminated against someone. So it's a pattern around how labor courts are actually seeing laws that are there to address discrimination or inequality in the workplace, that we are not going to let you assert it, but we are going to help someone defend themselves if someone says, by trying to create a protective environment, then this is what has happened. But what is interesting also about these cases is around this issue of a survivor-centered approach. So sometimes what survivor-centered seems to mean is that she said she wants counseling, and then afterwards she said she didn't want to do anything about it, right? So we talked to him, then it is fine, it's ended. And so if the employer decides to take it on, even after this person has said, I don't want to pursue it any further, the courts do not seem to want to allow the employer to do that, and that's what they call survivor-centered, right? whatever the survivor kind of. So even if you're not saying I'm doing this case because of her, because of course survivor-centered means that you respect her wishes, that I'm not disciplining him for you. I am trying my positive obligation as an employer that this predator cannot actually, be here. So it's quite interesting that what we are not seeing is really a lot of things around how to protect, the survivor. The first time I think we talked a lot about this tension between confidentiality and anonymity. And what has become clear is that obviously survivor-centered does not mean that the person is not allowed to know their accusers, because there has been people who are saying, of course, this is a workplace and I'm scared I'm going to lose my job. That what does it mean if I say who it is? But the reality is that's just like the basic of any kind of legal process, that you are entitled to know, who your accusers are. And therefore, in that case, you couldn't be, you can't be anonymous. So that's not what survivor-centered actually, means. But there is that interesting case where, and I think we are beginning to see this kind of retaliation, where if you're not, yeah.
Retaliation.
Okay.
I hate those retaliation cases. Before you go to retaliation, on survivor-centered, there's been some interesting developments in terms of the Labour Appeal Court. Mutsamai deals with survivor-centered in terms of saying sometimes an employer's policy says you must go to conciliation first. You must do the informal procedure first, then go to conciliation, and then the formal procedure. And the Labour Appeal Court there says, because then the person that was dismissed says the employer failed to take this conciliation approach, and the Labour Appeal Court said no. You must always take into account what the victim wants. And in that case, the victim was going to be too traumatized to go through conciliation. It would be ludicrous to expect the employer to actually go through that informal process. Because often employers say, well, we have to go through these stages. Often when people have been dismissed, we saw this in the Cape Peninsula Technicon case, the Hendricks case as well, where the person that was dismissed said, look, I had a right to conciliation because it was part of my contract. Because usually the policies form part of your contract of employment, and the policy says I'm entitled to conciliation, and the employer didn't conciliate. In that case, they said he must be reinstated because they should have done conciliation. And so there's been these conflicting decisions around the informal procedure, and there's been 2 Labour Appeal Court decisions now that have said you need to take into account the views of the survivor, which is useful. The other matter that we had was the MEC in the Northwest Province. The 2 parties there both met, and the woman agreed. It was very amicable. It was the principal and the teacher, and the harassment had happened, and the principal and the teacher met, and they signed something that he's apologized, she's fine with it. The MEC felt, look, you're the principal of the school and you're harassing a teacher, we still want to dismiss. So he said, how can you institute disciplinary action when me and the woman have agreed this is all okay between us now? And the court there said, because it's not just about the individual complainant, and employers entitled to say there's a duty, a broader duty to protect other women in the workplace. So if I go back to that case I hate so much, Mokoena, the one about the safari lodge where the woman was raped at the safari lodge, and they kept the rapist working there for a year because they were waiting for the outcome of the criminal case. There was a further duty on them to protect other women in that workplace. It wasn't just about the complainant and the perpetrator. So taking it by the Labour Court saying it's not just about that, it's about your broader duty under the Employment Equity Act is useful for us. But the converse of the survivor-centered approach has been in some cases where the survivor is saying in evidence things like we had a good relationship. They say, you see, she had a good relationship, she doesn't want him to be dismissed, she wants him to keep his job, we don't need to dismiss, the employer shouldn't be harsh. So sometimes it's used either way. And on the issues of confidentiality, the employer will often say if a complainant doesn't want to come forward, there's nothing we can do. That's the other point you've raised. The retaliation cases are really difficult because we're starting to see cases now where action is being taken against women where they say, look, you made an allegation, you were unable to prove it, and now we're taking disciplinary action against you and you're going to be dismissed. And that's going to be silencing a whole range of women in the workplace in a context where women need their jobs, they're often in the lower positions. So if you're a cleaner, are you going to take on this case because this could result in disciplinary action against you? It's the same thing like we spoke about last time in terms of the defamation suits that are being brought against women who speak out. And I think that also goes against the intention of the Employment Equity Act. It goes against the whole framework, and we must be careful of that. But unfortunately, we're seeing that happen at the CCMA level, and it's not being appealed. So you're only having CCMA commissioners rule on the dismissal of a woman because she's found to have lied about the case. And that's hugely problematic, and someone needs to take those kinds of cases on to appeal.
So it's then once again drawing parallels to other things that are happening broadly, that the causes and consequences, of this kind of jurisprudence that we have now speaks to legal empowerment, because if people know what the law is, but also access to our justice, very broadly. So people sit there and they worry about the consequences. So CCMA, you go there, you don't need a lawyer and all sorts of things. And so many cases do end up at the CCMA, and then people lose at the CCMA and there is no one to help them because the employer is no longer interested. We are seeing that when women, and black women, or poor black women in particular, lose there, that's normally the end of it. And so we then sit with this jurisprudence that is underdeveloped because these are things that are wrong in law that do need to be challenged, but they are sitting there because the people who have received these decisions actually do not have a way of taking them up all the way to the Labour Appeal Court so that good jurisprudence can be developed. So that's always at a pragmatic level around how we make sure that the law actually works, because we are seeing from the cases that the law can protect people, but it's those who are able to go all the way. Sometimes the CCMA does get cases wrong. In fact, most of them are quite wrong at the CCMA level. The law, the analysis, it's very clear how they struggle to understand power and all of its manifestations. So it's like, oh, it happened to you. This is what Section 60 says. Is this a workplace? Did you do it immediately? So, yeah, the way in which they do it, it's really like that kind of a checklist system. And then when they get overturned, and that's when you get to see the analysis, which really helps us to get there.
On that point, the Rustenburg decision, the Labour Court judge in Gauteng actually says there's an urgent need for training of the CCMA commissioners. There the CCMA commissioner's decision went on review, and he writes in such beautiful language. He says it's patriarchal, it's misogynistic, it's like the CCMA commissioner got it wrong, that it amounts to victim blaming, what the CCMA commissioner did. He quotes me too, and he says that's the most recent case, the 2018 case actually, the Labour Court, where he says there's an urgent need now, taking into account what's been happening at the CCMA, because not many cases go on review to the Labour Court. And he was saying this is really worrying and we need training, which speaks to a lot of what the international community is saying. Total shutdowns demands have spoken about this, the need for training and sensitization of judges, CCMA commissioners and lower court officials who are the first port of call for women in these cases, which reminds me of everything we've gone through with sexual offences. It's like, haven't we just gone through this with the rape courts, with the way women are re-victimized by police or at magistrates court level? Not everyone gets to the Constitutional Court to get a wonderful progressive decision by the panel of judges at the Constitutional Court. Have we not learned anything? Because now we're seeing the same pattern at the sexual harassment level. We've created a mechanism, a free access to justice mechanism, but it's letting women down. And maybe we need to really invest in a mechanism that's woman-friendly, that's gender-sensitive, which is something that the Australians have done. The Indian government has also said, actually you need women to head up these bodies, you need proper data collection, you need people that are trained and gender-sensitive to deal with cases of sexual harassment and to collect data and statistics that can inform future laws and policies that can't go through the ordinary court system, which reminded me of the specialized courts proposals.
So I think with just leaving South Africa for a bit, of course we're going to come back, and just looking at bodies like ILO and what's happening in other jurisdictions. And these are things that always come back from various UN treaty bodies or even the African systems when South Africa is being reviewed, to say that when you collect data, what's happening in sexual harassment, the fact that the data is not disaggregated is a problem, right? So we have to sit down and actually say, if we are saying women are winning, women are not a homogeneous group. But who are these women, who are winning? You see race, you see class, you see all of those things. That begins to say that the law reaches some people, but it does not reach some people. So that's one of the things that we really need to be pushing for on sexual harassment and how we're dealing with this at the CCMA. The issue of victim support, health and psychosocial support, it's something that we keep on saying, and people do remember around the passage of the sexual offences legislation when we woke up one Saturday morning to find out that the president had removed all of those things from the sexual offences legislation and said they were not costed, and therefore that's how we lost. But the reason why they were there in the draft bill was because this is something that people who are going through these processes do need. It's not a nice to have, it's not an optional extra. It is something that is key to people accessing justice, in the first place. When we worked at the Women's Legal Center, we used to work with a team of psychologists, and someone would come with a horrific sexual violence case, but that fact that the person has actually walked in to see lawyers was not an indicator that the person was going to be able to take the case, all the way. Because whether it's you who wants to take on the case, it's a real issue, or whether you have someone who's pushing you, whether you have a sister like me, like go for it, or you have a person who says get over it, We are not going to sit here for the next 2 years listening to you talk about your rape, Lots of people get raped around here. So do you see them making a big song and dance?
You did your job, you need the salary.
Yes. So the psychosocial support is quite key to people accessing justice. And unfortunately, most of the time we just delink it, because access to justice, it's something that people call legal representation, like do you have? But access to justice, it's much, much, much broader than legal representation. It's access sometimes can just be just as basic as physical, access, like can you even reach, that lawyer. So we also seeing these things around sanctions and remedies, so we do know that what the law says about automatically unfair, dismissals, or when people say they have been constructively dismissed, because it is also quite interesting that many people thought that women would leave the workplace because of sexual harassment and then go to the CCMA and say, I have been constructively dismissed, but there aren't a lot of cases, that are about,
all men.
constructive, dismissal. And you would think that it's all men because a lot of men have been dismissed, but no, it's most men who have been dismissed would go and fight it, right? So it's few men who have been dismissed for sexual harassment, but that's what they did with it. And then you have this kind of complete erasure or invisibility of women who have left because of sexual harassment, because then they would not even go to the CCMA to do constructive dismissal claims. So whatever the law says, I think that's what we try to do, that Section 60 of the Employment Equity Act has come in to be something that's helpful, but it has not been able to live up to that promise. And if anyone were to ask me, Section 60 common law, which way you want to go, the answer would be quite, clear, because what's good about Section 60, what I like about Section 60 is that at least it's not certainty, but the guidance around remedies, and sanctions, are there. That if the court finds this, then this is, the competent, remedy or the competent, sanction. But when it comes to the quality of the analysis, whether how the courts or the CCMA is looking at that, I'm not sure what it is that we need to do, but I think those cases that are sitting there, what we have learned from due diligence, it's that when we are talking about the obligation to respond to a violation, we're talking about investigation, we are saying it shouldn't just be an investigation, it must be effective, which speaks to the quality of the investigation. And an effective investigation is not the one that's going to necessarily lead to a conviction, because that's normally in a criminal trial, but even here a dismissal, but it must be capable of that, right? So it's about the people that you spoke to, it's about the due diligence, because this is what it is due. So how you're handling evidence, how other people, especially in a workplace setting, feel that they can be part of this process, that they can contribute without retaliation, that they will be fine. So what is it that we are putting in place to ensure that whatever it is that Section 60 has put there to say, this is how you need to do. So even if you report immediately, say that was not a dodgy thing to put, what are people assured of the process? Because right now we are seeing people who are shunning these processes because it's a waste of time, and it comes, with a lot of, the price is too high for victims of sexual harassment, at the moment, because it's not just that your job is not secured, but it's your reputation, right? You are the person who takes people on for sexual harassment, and you walk around, with that tag. And that's why many people who are victims of sexual harassment are anonymous, in all of these kind of processes. So you have unknown people who have been sexually harassed, because it is just not a sensible thing to do, to say that people have been sexually harassed. So it really is about what we have, what needs to be changed. So there are those things that are quite obvious, and the courts have spoken out on those, that we would need to go for the Employment Equity Act to do what it was intended to do. But there are also all of these other things that we would need to put in place to ensure that survivors and victims of sexual harassment are able to do that. So maybe you can talk a bit about the Australian stuff, and then we talk about total shutdown, because I think what I like about shutdown is Me Too brought home, you know. So Me Too is a global movement, but total shutdown is something that we can participate in and we can be part of. And just to be able to talk about some of those demands, that speaks to the things that are here.
Before I get to Australia, I wanted to just comment about the ILO. So the ILO has put forward that there's a need for a treaty to actually deal with elimination of violence and harassment in the workplace, and says there isn't one consolidated treaty globally. It's touched on in CEDAW, it's touched on by the Human Rights Committee, but there isn't one treaty for violence and harassment in the workplace. But what they did is they actually did an analysis, an 80-country study of what's out there at the moment, how countries are dealing with it, and they come up with, like, South Africa as being great. Like, South Africa is really doing well. We have this Employment Equity Act. Our law imposes vicarious liability. Few countries, most countries have laws around sexual harassment. And what the study found was implementation and enforcement is a huge issue, and interpretation of the laws and victim support. So all the things that Sibongile has been saying, they've basically found in this 80-country study that around the world there's no data, there's not enough focus on victims, there's not enough focus on amending workers' insurance mechanisms to cover things like this for psychosocial support. A lot of it is focused on the dismissal of the perpetrator and a perpetrator perspective or an employer perspective, but not a survivor perspective. And remedies, they say you need actually to have broader remedies available for complainants. And we actually have another act, the Prohibition of Harassment Act of 2013, that allows you to get a protection order. So people know the Domestic Violence Act, right? That you can get a protection order. So the Prohibition of Harassment Act is for outside of the workplace if you harass, sexually harass or non-sexual harassment. It has this strange terminology, but it allows for protection order mechanism. But they're basically saying, the ILO says that the level of sanction and remedy has been quite limited in terms of globally what people have thought about, and the most positive things have been this notion of employer liability, where they say South Africa is really good on that. Where Australia is better than South Africa is, Australia's act is very similar to South Africa's act, the Employment Equity Act, almost word for word the same. But they've got a body, which is their Human Rights Commission, which especially deals with sexual harassment and bullying in the workplace. And as they've laid out what does reasonable action actually mean from a proactive perspective. It's not, and they've actually said, like, it's not enough to just have a policy. It's not enough to have a policy on sexual harassment, not enough to just take disciplinary action. Are employers collecting data? What are employers actually doing around the positive duty after a case of sexual harassment? And I think in South Africa, our cases are treated as one-off bad apples in spaces versus what does this mean for the positive duty that the Act actually requires. And this body monitors your workplace after there's been a case like this. In India, they've got a system, the guidelines that have been laid out in India requires employers to involve NGOs and gender experts in the process from the start, from at the workplace level. And when it goes further, you need the assistance of gender experts, for example. So other countries have started to play around with what does victim-centered look like, what does remedies look like, and how can we do this better. But South Africa at the ILO level has been held up as being really good on the burden of proof. We've been really good on vicarious liability. So they lay out as examples that other countries can look at. They actually look at us. But when you actually see how things have been implemented, it's actually a bit of a problem. I worry about the fact that we have a lot of focus on another treaty. Like, it's another treaty what we need. Because I would say we put a lot of energy, I put a lot of energy, I think it was a year of my life in WLC, in the drafting of the Code of Good Practice. So we do have good policies, we do develop these laws, these policies, we flesh them out. And I really think we need to be looking beyond that, because that's not really providing a real relief for women. And that's why I like the mobilization that's happening outside of court spaces, because the law can only take you so far. The laws are limiting blunt tool, one of many tools that we actually need to be speaking about sexual harassment. And so I think we're going to finish now and you can ask us some questions, but I wanted Sibongile to talk a bit about the demands of total shutdown, which are quite similar to what the ILO's pointed out is needed.
So when you look at demand 3, the 24 demands, it's that the acknowledgement that when we are talking about gender-based violence against women, we're talking about a form of discrimination, which is overwhelmingly gender-specific. It happens to women because they are women, you know, and then people would say, men get sexually harassed too. Yes, they do. And the law protects them well. But if we do not look at the causes and consequences of discrimination, and we are looking at the law in a way which is gender neutral, we don't get to the heart of why these things actually happen and how the power sort of manifests itself. Demand number 10 really speaks to the issue of consistent sentencing and enforcement of existing laws. So it's always debatable whether our laws are really good, because people, it's like a very South African thing. Our laws are good, the problem is implementation.
Interpretation.
But sometimes when you see them, you can actually do find a lot of gaps that we may do well, you know, to fill. But demand number 10 doesn't just speak to the enforcement of existing laws, it also talks about these harmful and negative gender stereotypes, like victim blaming and slut shaming. And we do see this in sexual offences cases, but what we are seeing in sexual harassment cases is, why did you respond like that? You know, why didn't you just let him know that you don't like it? You know, because remember the old definition of sexual harassment as the form of unwanted attention. So unwanted is, it's basically like women walk around consenting.
Yeah, in a constant state of wantedness.
Yeah, and so you must then communicate the unwanted, you know, because then the person is not going to get it that it's unwanted, even if they are making you feel uncomfortable, because they don't have the obligation to know what's acceptable behavior in the workplace until someone has actually sorted them out, you know. So, so these harmful and negative gender stereotypes, you know, like, but if she wasn't happy, you know, that person would completely tell you off, because we're always walking around telling people off. Demand number 12 talks about judicial training on discrimination broadly, and says that this has to happen from appointment, and it must also happen at an ongoing kind of basis, you know, because there used to be those kind of judicial training, and I think that they still have them at the Judicial Services Commission. Is that what the word? No. What's this? The Justice College. That's where they were. But sometimes it's people don't go back afterwards. But what the total shutdown says under demand number 12 is that they also have to really see these decisions, the bad decisions that they and their peers continue to make when they actually fail to uphold, you know, women's rights to be free from violence. Because the problem is, most of the time they feel attacked, you know, if they hear that they are in a newspaper because someone has written, or in a research report that they are actually misogynist in the courtroom, right? Then it's something that they take personally. But if this was part of their education, you know, to cure their miseducation, to say that in a courtroom you actually cannot do this, you cannot say that. So that's demand number 12. Demand number 15 really speaks to intersectionality. And when we start collecting data, and then we begin to segregate it, then we begin to see who is left out, you know, who continues to be outside of the margins, you know, of the law. Because if we keep on talking about the law as if it reaches all of us in the same way, then it actually, you know, doesn't. In fact, this week in the total shutdown, the Facebook page, men cannot join. So you are hearing about this from sometimes you have people who are trying to provide advice, to people, but they actually themselves don't know how to provide or to support survivors, of violence. But you can see that people are speaking from a position of privilege. So the things that are discussed, they are confidential, but this came from actually another Facebook page that someone left. So it was an open Facebook page, that's why I'm able to talk about it. But what happens is when someone says, I am a victim of violence, right? And then because we all now women, for the total shutdown, and then people start saying, I don't feel sorry for you. It's like, no, but the person didn't ask you to feel sorry for them. It's like, why don't you leave, You just want, but really not understanding all that goes in there, why people stay and why people leave and all of those things. And it's even worse in a workplace kind of a setting, because it's about your survival, it's about your livelihood, yourself, your family, and everything else. So leaving is not the next thing, it's not the most logical thing that you're going to do, which is the same in domestic violence cases. People act like the two choices are you want to die or you want to live, Like you don't have to factor where you are going to live when you leave, or you sort of go to. And so this those are some of the things. I mean, there are things around shelter that the demands actually look at. So why do you think that the demands are important? It's that because it has given us a framework for hoping. Some of the things aren't things that are not unnecessarily new. In fact, most of them aren't new. These are things that people have said. But it's the recognition that legal and policy work is definitely going to need mass mobilization work. We can't be sitting here having these conversations among ourselves. And we have seen that, what it means, because it becomes a platform for legal empowerment, right? So when people are talking about the demand, it may look like one small demand, but basically it says the things that we are talking about here, about Section 60, and all of those things. And I think it becomes an important way of doing mass mobilization about the law, because in South Africa, when people are rejecting the Constitution or the legal framework, one of the things that they say, which is very true, painful as it is, the law has remained largely elitist.
We can end on that positive
Okay.
note. Just nature of the law and open it up for questions to everyone.
Good. So thank you to both of you. When they wrote to me last week, they said, I see you've given us 2 hours. We're definitely not going to need all that time. And here we are 1.5 hours down, right? So okay, so questions. Who's Ruth and then Marva? Any other hands so far? Liz? Okay, so Ruth, Marva, Liz, and then we'll take some more.
Thank you so much. This was so informative. I enjoyed every moment. So for me, it was a question, but I think you've answered it. But I'll just say it because it's blocking my mind. So I find labor law very, very limiting, and it has very strict. I don't think it has strict boundaries which need to be pushed, obviously. And when we speak about sexual harassment and labor law, so there is labor laws and then Employment Equity Act. For me, the Employment Equity Act, and equity is the word here, for me is the window through which to expand these limits of labor law and bring in the human rights standards. So you spoke about due diligence. I've done some work on due diligence. And if, for me, that Employment Equity Act, and equity again the keyword, if it doesn't keep the door open into human rights due diligence to bring in that kind of rich analysis around protection, fulfillment, promotion, then it's dodgy. It remains, for me, it's just part of the very limited labor law. And so I'm not surprised that ILO thinks South Africa is doing great, because, again, it's within the labor law space. It can seem as though the jurisprudence on vicarious liability is very progressive, but in fact it's not. And so in some of the due diligence work I do, some of the reports that have come from the due diligence project have also described South Africa as having one of the richest jurisprudence on due diligence. And that is not true. If of course, and again, because I work in violence against women, so because some of these cases around sexual harassment and violence against women seem as though they speak about obligations, it is easy to think that it is a progressive jurisprudence. But in fact, it doesn't. It is not progressive, and it doesn't do the thing that we want it to do, which is to unpack where does the obligation actually lie? Where does responsibility actually lie? So for me, I think my frustration is that if we keep thinking that we will deal with sexual harassment within the limits of labor law without really kicking that door open to bring in the analysis of due diligence and really the feminist analysis, then it pretty much remains years and years of work there's no progress. And the answer that you gave me, which I'm very happy, and I think is really about access to justice and who has access to the courts. And so whoever has access to the courts actually determines what the jurisprudence is. So it's a way up, but it's also the way down. It's literally parallel, and so it keeps feeding the jurisprudence that's coming out, keeps feeding the problematic space that's in the practice, and then it just reinvents itself. So I don't know how to break that cycle, because it seems as though it's progressive, but actually it's not. And I'm worried if ILO wants to have a violence against women treaty and a sexual harassment treaty, because that means that, again, at that global level, we are going to perpetuate the cycle of thinking we are making progress, when in fact we are not making any progress.
Marva?
She said quite a number of what I wanted to say, and I'm like, no, I don't want to speak after. But my question comes to the fact that the law is elitist. And I'm not a lawyer, but I live on the Cape Flats and a community worker. So my question would be that many people don't actually have a contract between an employer and employee. And many companies don't have even an HR. So the question I want to ask is, how do we level that up to people in informal working relationships and contracts where nothing is written down, but they've been working there for a while, and many people in those situations get violated, and nobody worries about them because they don't know about the Women's Law Clinic, they don't even know their rights, but they know that they've been violated. So my question is, how do I take what we've done here today to Bonteheuwel and make access to justice, access for ordinary people who are sitting with these questions that we've been discussing today? Because CCMA, and very male-dominated, a lot of white males, and sometimes the white males, the black males, and all the males, I just think the same, but we can't put people in a box. But then we're saying that demographics has to change, but how do we do it as civil society with people with the legal capabilities? How do we work together to bring that change?
Liz.
My questions are relatively short. First, have you ever received cases where it's the male employees who are alleging sexual harassment? I'm just curious. And then secondly, are there protection measures for employees working in other workplaces which are outside the office? For example, if a company signs its employee to a conference, for example, I don't know what's the governing law. And then my last question is it fair for the employer to bring evidence of sexual harassment from outside the office to lay grounds for them to suspend or take action for the employees at the office? Like if an employee is facing a sexual harassment investigation, maybe in his school, for example, can the employer rely on that to also bring an action, even if there's no evidence of sexual harassment of the same person in the office setting?
Either.
Okay. I missed the third question.
Oh, the applicants for the job. I'll start and
Okay,
then
okay.
maybe starting with the last one. The case law, that was the Labour Appeal Court decision in Simmers versus Campbell around you don't need to be in the workplace. It can happen outside of the workplace, at a conference, at an event. They were on site in Botswana. They weren't even in the country having dinner when it happened. And they said that's still part of your employment relationship. If you were, for example, employers would have to take into account I would say the duty to prevent discrimination in the workplace would require you to take into account if an employee of yours is being charged somewhere else under the Prohibition of Harassment Act or domestic violence or in another space. You could use the Employment Equity Act then to say there's a duty on us to ensure an environment free of discrimination, and we're not going to tolerate that. We've seen that happen in the racial discrimination cases. You send a message using the K word and you say, oh, it's my private message. Your employer can say, we don't want people like that working for us, even though you were being racist on an aeroplane in a private message to someone else. Your employer is entitled to dismiss you, saying that's not the standard we want within our employment context. And we're not going to wait for that case to run through the equality courts. We're going to just make a decision as employer that that's not what we stand for. I'm hoping employers will do that more and more for domestic violence, for other acts against women, where they say that's not what we stand for, and the fact that you are a perpetrator, we don't want that in terms of our Employment Equity Act. And this takes me to the Employment Equity Act. Maybe we've been a bit harsh with the Employment Equity Act. Section 60 is problematic. But if I was a judge in the court, I could work with, a feminist judge could work with Section 60, and there have been judges that have worked with it, and there's other provisions that are useful. Section 6 is really useful, and it helped us in terms of saying sexual harassment is a form of discrimination. That's a very important legal, to have that out there, because in other jurisdictions it's taken them 20 years of litigation to show that sexual harassment is a form of discrimination. The fact that our Employment Equity Act said that in 1998 is like a useful tool for us to work with, and it's helped us in terms of our battles. But there's always a next frontier. So there's other provisions. Section 50 is also a good provision in the Employment Equity Act around relief, appropriate relief for people. So it's not all bad. The Employment Equity Act also is not as limiting as the LRA in terms of the definition of employee. So an applicant for a job is covered by the Employment Equity Act, whether you get the job or not. So in your process of applying for a job, if someone's racist towards you, sexist towards you, you can use the Employment Equity Act to challenge them, which I think goes to your question. So that wide interpretation has said, because this is about dignity and equality, and the Employment Equity Act is a piece of legislation giving effect to the Constitution. So it's going wider than the LRA in terms of definitions. But it doesn't go far enough. On the access to justice, it's a problem. The kinds of cases we've seen on affirmative action, who's brought the most cases on affirmative action to our courts? White men. Our racial discrimination jurisprudence is skewed. So you have our jurisprudence being skewed in the discrimination realm around certain population groups, whether it's about racial discrimination or gender discrimination. On the CCMA, I forgot to mention, there's an interesting case, if anyone wants to go read it, about a CCMA commissioner who was charged with sexual harassment by AirPay. A senior CCMA commissioner charged with sexual harassment was dismissed, and he challenged his dismissal all the way to the Labour Appeal Court, where the court said to say, this is the CCMA where we're sending women to go and bring sexual harassment cases, and one of the senior commissioners is charged with sexual harassment and is challenging his dismissal and challenging the evidence that's led by the complainant. How do you then put that CCMA commissioner before another arbitration? We must remember judges, who judges are, they're not objective, they're not impartial. Who CCMA commissioners are, they come with, whether it's masculinist reasoning or feminist reasoning, the way they interpret. I could use the Employment Equity Act and do wonderful things with it if I was sitting on the bench, for example. But we don't have the luxury of feminist judges on the bench.
So I think the question around people who don't have employment contracts, one of the good things that has come from our it's a functional test of employment, right? So even if you were to call a person a contractor, is this person working for you, you know, whether they have it written down or not, you know, they come to you 9 to 5, 8 to 4, whenever. So that is an employee-employer relationship. And I think that helps us, you know, to move into the substantive questions, not whether there is a relationship, you know, that happens, that exists between, you know, these two. So what is this substantively about, you know, this relationship? The other thing around evidence from outside the office, there is a conversation that's going on now around this disclosure, because people are saying sexual harassers are just moving from this one company to the other. And I think in the first conversation we were talking about this thing that was called, or is still called, the non-disclosure agreement, which are really secrecy agreement, right? Because it just says keep quiet about it, you will lose your settlement if you talk about what has happened. And so people are saying the conversation in the social justice sector, should we be making this information public if a person leaves with a sexual harassment, you know, record, whether that would be relevant in determining whether the person gets a job, but also if there is an issue of sexual harassment that arises in the workplace. And I think that's a conversation that's out there, but it's a very real conversation, because other people leave without having had the benefit even of a case. You know, they just resign, but it is something that hangs, over them for as long as that allegation has not been dealt with. So in some ways, is to even say, I am going to go, but if I think that I am innocent, then let us conclude this, so that there is something that a new employer can always go back to, because that's how people sort of run, you know, from organization. So, and I do think that if we have something like that, it is something that would have to be admissible, you know, the new employer, because this is your track record. This is how, you know, you work. This is how you behave, you know, in a workplace. And people need to be able to make that decision. We ask for references. Why is this not a valid question to ask? Have you ever been accused of sexual harassment? Have you ever been found kind of guilty? We say criminal record. This does not go to your criminal record, but it goes to your employment, you know, record. So I would say yes, it would have to be, you know, if it isn't something that we consider when we are looking. So even if it didn't happen here in this workplace.
There was another issue around how do we get this to the women in volunteer law. And I think the issue around knowledge of the law, knowing your rights, I think this is where other movements, lawyers can't do everything, but the alliances that need to be formed with unions. I think the role of unions and unions bringing more of these cases, or workers coming together as solidarity movements, or women within a certain space coming together and saying we want to challenge this, whether we're challenging it on the streets, whether we're challenging it in the press. You know, workers have a history in this country of being able to immobilize employers, and women workers coming together to say this is not acceptable, this is the standard we want, this is the conversation we want to have with management. How we equip women to do that, and not just go and equip women to say this is how you fill out the CCMA form, this is the legal process, but actually the mobilization that's needed within a workplace or with unions. And often this, you know, in any male environment, it's often difficult to have these conversations. And how do we empower women to do that? And what's the supports that the NGO sector, the lawyers, what's the role of all the different players in that exercise? Because I think as people get to know what their rights are and how they want to proceed, and we're giving them different options, that law isn't, the CCMA and the Labour Court isn't just the only option you can take. There are other options that people can use. I think that's one way of doing this. And then there are linking up with other movements like total shutdown, or linking up with access to justice places that could service indigent women that can't access lawyers, like the Women's Legal Center.
I mean, I think just going back to our example, total shutdown demand number one was that the president announces the date for the summit, which did happen, and that on the 9th of August, he sends a very strong message, which he has failed to do until now, that violence is unacceptable. So he hasn't said that, but also makes a commitment not to hire, not to get people who have been accused or found guilty of sexual violence, not to include them in the cabinet or to lead institutions. So when you think about that as a demand that we could make in our workspaces, you know, as a demand that we all entitled to, because if someone had a protection order or even had been, you know, on those things, a protection order against them, because a prima facie case has to be made. You don't just get a protection order against you. That is something that is important, because in terms of just sending a signal, so not just by the president, but us as something that we mobilize, you know, around, and just taking it to wherever we are in our communities to say that these are people who should not be leading. Because right now, there is no stigma on violence against, you know, women. There's a lot of things that should carry stigma, you know, like rape. Victims of violence carry the stigma, right? But not the perpetrators. Like it's fine. You know, you can just go in there, whether you call it an apology or whatever it is, but you are fine. Like, there is nothing that has happened, you know, to you as a perpetrator. You may be convicted if you are unlucky, because it has to be unlucky, because many people do it and then they're actually out on the streets, and to be able to go there. So it's really about having this concerted message that we need to be very deliberate about, that this is something that is wrong, and that's how we begin this big work of really changing the cultures, the values, you know, that enables these things to happen. Yeah.
Is there another round of questions? Go ahead.
So I just wanted to ask, I think maybe it's part of a bigger problem, is that is part of the problem we have about sorry, my voice is a bit wasteful right still. It's part of the problem that we have with sexual harassment, that when it comes to something as serious as rape, there's such a difficulty with getting your voice heard. So were you really raped, you know, what were you wearing, and then the success with which, you know, women who report rape get, you know, convictions for the crime that was committed against them. Is that not part of the bigger problem? You know, that in tackling sexual harassment, we also then have to tackle this bigger thing, because I feel like in certain instances you have people who've been raped who go, I can't really take this sexual harassment thing forward, because when I was raped, no one really listened to me.
Yeah.
And this is something that's to a lesser degree, and well, I mean, it's still very like big, but you know, they feel that if they couldn't get success there, then they're less likely to get success here. And then my second question was just in relation to the support that's given for sexual harassment survivors. Because I mean, coming from a foreign perspective, you always recognize that there's support for people who belong in the space, but then as someone who's trying to claim their identity in a space, so we had someone from the refugee rights clinic, you know, where you struggle so hard to get refugee status, and someone commits that violence against you, and then now you're torn in between this process where you're saying, well, if I go complain, well, I may or may not get justice, but most likely I'm definitely going to get kicked out. and actually just, you know, standing up for your rights, you know, because I mean, South Africa will always be like, these rights are available for everyone. But the flip side of it is that if you don't belong here, you may have your rights enforced for you, but then you may also get kicked out in the process of your rights being enforced for you. So how do you guys then feel like you can strike a balance between those two things? Because I feel like it's such a gray area, but I'm sure you guys would know. But it's such a pertinent issue in South Africa. The treatment of migrant laborers, especially those who come from foreign countries, more especially undocumented migrant laborers.
Norina?
Thanks to both of you for very interesting and at some points very depressing insights. I'm interested in how either in the common law context or in the labor law context, have the duties of employers to protect employees against third parties being developed. So when it's not two employees that are at issue, but an employee and an external client or party or something else.
What, any last question? Good.
I think your point is exactly right around, this is part of a broader narrative and a broader problem around the harmful norms and cultures and stereotypes and myths that play out in terms of all sexual offences, including sexual harassment. So if you see sexual harassment on that continuum, all the issues that we find around when does no mean no, everything that plays out in a rape scenario plays out in a sexual harassment scenario. And the way, whether women are believed or not, what your status is as a complainant is the exact same scenario, which makes women not want to report. And so the underreporting of these cases is a similar issue, and I think you have to address it collectively. And that's why we were trying to make the analogy around sexual offences to show that this isn't something that's just about sexual harassment. It's actually a broader issue, and it's really around the norms and acceptability that Sibongile was mentioning, that some forms of violence are just tolerated and seen as acceptable masculine behavior. And that's why you see problematic judgments and reasoning coming out. And the silencing around, the issue around immigrants came out. The ILO actually said the groups of people that are most invisibilized and struggle to find protection around the world, and that they developed special protective mechanisms for, is immigrants, domestic workers, night workers, and part-time workers, are the most difficult in terms of accessing protective mechanisms because of the fear that it's going to have other repercussions. And I think that plays out within this context as well. Most people don't go and report if it's the same thing you find in other parts of the continent with LGBT people not wanting to go forward or claim services for fear of being criminalized. And so I think we need to work around that, but that's going to be very difficult because you're going to need some cases again to go to court where you're saying your undocumented status is not the issue. The issue is you have a right to not be violated and to be protected from sexual harassment, and so that shouldn't ever be an issue. You should be able to claim the protection, but the chances of people being willing to risk that and come forward is the same like a woman risking coming forward and subjecting herself to secondary victimization. Norina, there's been some case law in the High Court, particularly around non-employees, and it's been doctors that have brought cases against the MEC for Health, doctors on duty that were raped by non-employers, by the Department of Health. And there was a few high-profile cases like that in the newspaper people would have seen, where they have been successful in terms of claiming damages under vicarious liability, and where the judges are actually speaking about safety in the workplace. So then your claim is around your duty to fair labor practices, which is a constitutional right, and your right to work in a safe environment, and your dignity and equality, and constitutional damages. It's nothing to do with the Employment Equity Act. So the cases that have developed, and then there was that old mutual case. So it's interesting, most have been against government, against the MEC. There's been a few with the Department of Health, with women doctors that have been raped while on duty at night in different provinces. We've seen those cases come up, and the court developing your duty even for non-employees to protect people.
Tabitha?
Sorry, just had one question around donors. And
She has a question on donors. You have to speak up.
sorry, so specifically talking about the public interest sector and the liability of donors instead of management level.
Sorry, I'm not understanding the question.
Sorry, so like, so there's an instance within an NGO, I mean, often the kind of power structures happen within not the donors, the boards. So,
Yes.
sorry. Yeah. I was thinking about something else and then talking about the question that I thought of. Sorry. So when you're talking about holding the board responsible for the organization instead of the directors, is that at all possible?
What could happen? You'd have your claim. A public interest, whether it's in the public interest law space, you could hold the employer liable if the employer failed to take action, and the employer would then look at either whether they'd look at what the executive director did, whether it was reported to the board. So all the tests that you would apply because that's a workplace. So women could go forward and bring a case against an employer, say, it's brought to your attention, you didn't take any action, you didn't take any reasonable action, and we're holding you liable and suing you for damages, and then that would involve the entire institution. And it would obviously have a big impact on their funding, but that's a completely possible case for people to bring. There is a duty on the board and the executive director in any space and in any work environment to fulfill the duties of the Employment Equity Act, all the duties, whether it's around race or gender or affirmative action. So the public interest sector isn't separate from, or the fact that you're a social justice organization doesn't mean you are somehow.
But you can go directly to the board for liability.
It's not it would be the organization you would sue, the same way you sue Liberty Life or Anglo Platinum. You're suing the entity, so you would sue the organization, like the Women's Legal Center.
So I don't know if this speaks to what's the extent of their fiduciary liability, whether they are personally liable and all of that. And it actually depends on how the organization is set up, because there are quite different ways of setting up the organization. And then in that way there are different powers and responsibility that the board has in relation to it. So it's a factual kind of question around whether these ones are personally kind of liable. I do remember in the mid-2000s that there was a beginning, and I don't know how far it went, of a push around really going to the board and holding them kind of personally liable because of the failure to exercise due diligence and just looking at their fiduciary, responsibilities. And it's normally, in NGOs, for example, as opposed to boards where people are paid to sit there, it's normally felt like it's a favor, the service that people give you their weekends to go and look at your financial reports. So it's like, don't go hard on them, because there is some kind of an acknowledgement, that yes, it's a board, but it's not going to be as diligent as ESCOM's board should be, So in that way, the way people set up their boards is that they don't then get to incur that. But it's a longer conversation, because you have boards that straddle the divide between the governance function and operations function. It's like, this board is really working here, because of the decisions that they take. And in a lot of sexual harassment cases, what you are beginning to see in the social justice sector is basically this straddling the divide, that this was not a board decision to make, you know. The board should not have been anywhere, you know, near this, the extent of their engagement was really about crossing the line. So even if you want to protect them, it's like, you can't be protected. You really actually messed up because you came here and you made like decisions around human resources, you know, and all of those things. So in the conversation around social justice institution, I really do think that there is a need to interrogate the role of governance, you know, structures, because a lot of people that want to help, they mean very well, but they are causing a lot of damage.
I think the board only has a role to play and has to be active if it's the executive director, that's the sexual harasser, but otherwise operationally the executive director has to address all disciplinary matters internally. So if there's a sexual harassment case within the organization, the executive director has to take all the steps, do everything under the Employment Equity Act, and all the board has to do is oversight to make sure that the executive director is acting in terms of the Employment Equity Act. But if the executive director himself is the sexual harasser, the board has to be much more involved in terms of suspending the executive director, because the executive director wouldn't suspend himself.
Can I ask a last unfair question? If you were a 20-something whippersnapper, young social justice interested lawyer sitting in the room right now, what would you do on this issue? Think back just a year or two, right?
I take myself back 25 years or something. No, I think this is an exciting space to be in right now. I'm actually doing all of this and looking at everything. I think there's some academic work, that some interesting work could be done. There's a master's or a PhD in here to analyze race and class and gender at the intersection of the judgments. If I was a student, I'd actually be applying to do that now. And then I think it's an interesting space to be in the public interest field, where you're providing a free service, but you're developing the law. I don't regret being involved in a case developing the law on vicarious liability, and there's so much more that you could still develop. And if you're not a lawyer and you're mobilizing communities out there, I think this is a good space to be in. It's a space that's relevant, that you can see yourself making a difference. There's a global moment, there's a global movement that's filtering down to South Africa, to the continent, where there's stuff that can be done both inside and outside of the court, and to play the insider-outsider game, and to be involved with government in terms of developing better policy. So you've got a range of opportunities, and we need more gender activists, and we need more gender specialists to go out there and fight the good fight.
I think it's a question. Am I the lawyer that my clients deserve? You know, because most of the time, lawyers in public interest circles would complain about clients not coming back, not acting like they are interested. Because what does it mean to be the client, the lawyer that our clients, you know, deserve? For a very long time, the public interest sphere has struggled with lawyers as know-it-all. And so part of the critique about public interest lawyering has been that lawyers want to lead social movements, you know, even if they are there in whatever capacity. And it's a very interesting mix, as we are seeing a lot of social movements come up. Way back then, there were very few social, you know, movements. But something that really needs to be made, that needs to trend, is that social movement lawyering is not just a name. You know, what does it mean to be embedded in social movements? Because basically, it's about understanding what the community wants to achieve, and then getting behind them and pushing in whatever direction that they are going, not just based on what you think you can win, you know, in court. One of the examples is around how the celebrated US decision of Brown versus Board of Education was not necessarily what some people in the community actually wanted, which was about taking black kids to deal with the segregation policies in the US into white schools. That what was possible in the law was to say that, looking at the American discrimination framework, you cannot say that a black child cannot go into a white school. But what parents really wanted was decent schools for their children, right? Not in their communities, not kids walking into a classroom escorted by the police because white people actually do not want that. So the question that I'll ask myself is, am I being the lawyer that my clients deserve, not the one that I believe that law school wanted me to be?
Thank you. What an awesome note to end on. And again, just thanks to both of you for making the trip from Joburg, for spending the time with us, and we hope there'll be installment 3 sometime.